Justice Neil Gorsuch may just be about to get his revenge for his mother? Whose mother? All right, that's enough with the your mom jokes out there, but it's actually true in this case. Justice Neil Gorsuch's mother was the head of the EPA during the Reagan administration, and she was very unceremoniously drummed out of her position in government. And if you read her memoirs, which I'm very excited to read this upcoming week because I just found out about this story, apparently Justice Gorsuch thought that she shouldn't have stepped down. But there's a bigger story behind all of this, and this is the dismantling of the bureaucratic state, which may begin to unravel, hinging on one Supreme Court case. Joining us now to discuss this case is Thomas Berry. He's a research fellow in the Cato Institute and the editor-in-chief of the Cato Supreme Court Review. Good morning, Tommy. Thank you for joining us.
Good morning. Thanks for having me on.
So give us a little bit of background here on this case. Not a lot of people are talking about this, Thomas, but when I see progressive blogs freaking out about the New Deal possibly being overturned, that gets this libertarian excited. What's the story here?
Sure. So this is a case called Loper Bright versus Raimondo. It's a challenge to, sounds very exciting, herring fishing regulations in the Atlantic fisheries. Some people, if they've seen the movie Coda about the deaf fishing family, these regulations were actually played a part in the plot of that movie. These are about the monitors that small fishing boats have to take to make sure they're not catching too many fish or that their fish aren't too big, and whether they themselves, the fishing boats, have to pay for those monitors. You might think it's, rough enough being forced to carry government monitors, let alone the indignity of paying for your own essentially the police force monitoring your own compliance. But that's what the Commerce Department tried to do. And the issue is that the statute is silent. It says you can force them to carry monitors, but it doesn't say you can force them to pay for their own monitors. So what do you do when a statute is silent? You might think that the government doesn't have that power unless it's explicit within a statute. But under Chevron deference, which, as you said, very easily could have been called Gorsuch deference if the case caption had gone slightly different. Under that rule, if a statute is found ambiguous by a court, the court is forced to defer to a reasonable interpretation from the agency. So what happened here at the DC Circuit is the DC Circuit said silence is essentially ambiguity. And so therefore the tie goes to the agency. And of course, the agency is always going to say, we interpret this to give us more power, not less.
So let me just tie this up for our listeners, and you tell me if pick this apart if I'm incorrect or confirm if I am correct. As I understand it, what this is this is a Supreme Court case by fishermen in the Atlantic. And what they are arguing is that, yes, okay, they have regulations where there is a fishing monitor that is going to be on their boat, a government a government regulation, but that they shouldn't have to pay for that monitor to be there. Now, that court, they lost their cases in lower courts. Now it's gone to the Supreme Court. But the reason why this has such overarching implications is because up until now, federal agencies, these bureaucracies, have had wide leeway in how they interpret rules that have been laid down on their agencies. But what Justice Neil Gorsuch may be about to do is to take the power of these bureaucracies to essentially write laws to a certain extent away from these bureaucracies, which would sort of gut the rulemaking or lawmaking power that many of these bureaucracies, the DEA, the ATF, the EPA, the USDA, to take away their power to set these rules and regulations and fines, essentially, or fees, if you will, on top of businesses. Is that correct?
Yeah, it is. I would draw a distinction. There are two ways in which the bureaucracies really can have outsized power. One is in writing the rules, and then one is in interpreting the rules. So in my view, they infringed on both the Article 1 power, that's the legislative branch, and the Article 3 power, that's the judicial branch. And the way to think about Chevron is that's really about Article 3 power. So what this case really digs down into is even after the statute has been passed, even after a rule has been written, Then you have judicial questions. Is this rule allowed or not? And that's traditionally, you would think the Constitution says all judicial power is vested in the judicial branch. And yet here, when you defer to an agency, what Gorsuch and others, I think, have convincingly argued is you're essentially giving judicial power to the executive branch.
So explain it to me like I'm five, Thomas. I was a musical theater major, but I did run for president, so I know a thing or two, but I am not a genius. If I'm correct here, this would scale back the regulatory power of these agencies dramatically. Is that correct?
That's absolutely right, because what they've been allowed to do with Chevron deference is every close call goes in the agency's favor. So courts are very, like everyone in any job, people have to realize judges are just people, and people always like things that make their jobs easier and less work. And Chevron deference gives judges less work. They don't have to dig down. When they get a tough question, they don't have to spend another week digging down. They can just say, this is close enough to a coin flip that it's ambiguous. And that's one of the big problems, is that no one really knows how to define ambiguity. But if it's anywhere close, most judges will say it's ambiguous. We're going to just defer to what the agency said. And it doesn't really make sense, because okay, perhaps agencies have some expertise in the subject matter. They know about fish, but that doesn't mean they know about judging. That's specifically what judges, Article 3 judges, are supposed to be confirmed to have: legal skills and statutory interpretation skills. And that's what, kind of surprisingly, the executive branch has been allowed to do for 40 years since Chevron was decided, is put their own stat interpretation of the statutes that decide their own power.
This is big stuff. If you're just tuning into the Wake Up America show, good morning. My name is Austin Petersen. We're glad to have you here. Make sure you click like on the channel that you're watching us on to help fight against big tech censorship, beat the algorithms, and help spread the message of economic freedom and personal liberty, which is what I'm all about. And of course, my guest, Thomas Berry from the Cato Institute, is as well. We're talking about a Supreme Court case that could have a massive impact on the bureaucratic administration state, or as many people are calling it lovingly these days, the deep state. We're going to talk about this in a little bit more detail now as we head into what we like to call big brain time here. Now, Thomas, the article that caught my attention about this yesterday was written by a progressive journalist by the name of Tom Hartman. His article title was "Neil Gorsuch is Preparing His Revenge, Gutting America's Protective Agencies." And he paints this in, quite possibly hyperbolic terms, maybe or maybe not. And that's really what I want to have you clarify for us, is that Hartman writes in his piece here that, one, that he tells the story of Justice Neil Gorsuch's mother, who was the head of the EPA, who dialed back their powers and their budget to a massive extent, which was quite fascinating and I wasn't aware of until yesterday. But Hartman writes in his piece, if they pull it off, they could destroy the ability of the EPA to regulate pollutants, the USDA to keep our food supply safe, the FDA to oversee drugs, OSHA to protect workers, the FTC to regulate monopolies, ATF to regulate guns, the Department of Labor to protect workers' rights. Obviously, he paints these in very, hyperbolic, massive, like overarching terms. But is there a grain of truth there? I mean, would this have as big an impact as the progressive left and even some on the progressive right are claiming this could have?
It would have a huge impact, but I think, taking a big picture point of view, it's important to stress that this isn't just about conservative versus liberal, big government versus small government. I see this in the longer term as about judicial branch versus executive branch. So 40 years ago, the policy roles were reversed. The Reagan administration, Gorsuch's mom, were deregulating. They were initiating conservative policies, and they wanted deference from a mostly liberal judicial branch. And so 40 years ago, Chevron deference was seen as a conservative doctrine. Justice Antonin Scalia was one of its biggest champions, and it was mostly just a kind of an idea of the ends justify the means. It allowed deference to a conservative president. So right now, under a Democratic administration, yes, Chevron deference allows deference to bigger government policies, But I think in the longer term, it's not about, do you want, conservatism versus liberalism? It's, do you want the judicial power to be in life tenured judges or in bureaucrats, who are neither elected nor often even appointed by the president, and certainly don't have the same remove and sort of training in dispassionate legal analysis that the judiciary branch is supposed to have.
Thomas, when are we supposed to have this case be decided and figure out the outcome of this?
Yeah, so it's going to be argued sometime this term, likely after the new year, sometime between January and April, and then it, like all cases in the terms, sometime by the end of June. You don't know any more specifically than that, but the court always gets everything off its docket by the end of June. So June 2024, we should know.
Thomas, you work at the Cato Institute. I imagine we probably agree on 80-90% of things. We're a very libertarian talk show in the morning. Are you excited about this?
Absolutely. I think it's the biggest case of this term. And you're absolutely right. It's not getting enough attention. Chevron deference tends to be something that people see as wonky, as something only lawyers care about. But anybody who cares about democratic theory, who cares about, will questions that affect them be decided by a life tenured judge or by a political leaning bureaucrat in the executive branch? Everyone should care about these. And as we say in our amicus brief supporting the fishermen, it's really about due process, because when a thumb is put on the scale for the person the side you're opposing, that's not really that's not a fair and impartial judiciary.
I see that several institutions have come out and supported an amicus brief in favor of this. With the conservative majority on the Supreme Court, how confident are you at this point that we could see this happen? Noting the legal views of Gorsuch are fairly different from that of Kavanaugh.
I'm fairly confident that the Fishers are going to win this case. The whole question is, will it be a bigger win or a small win? Are they going to just flatly say Chevron deference is overruled, there's no deference whatsoever? Or are they going to be more incrementalist and say we just need to dial it back a little bit, or maybe set a new standard, making it harder for judges to find ambiguity? But I'm hopeful. I honestly think, I don't know if there are 6, but I honestly think there are at least 5 justices on the court. Even some of the justices who can be swings, like Chief Justice Roberts and Justice Kavanaugh, they've both been very strong on separation of powers issues related to too much power in the administrative state. And so I think both of them really do see this as a philosophical issue. And I think it's telling that the petition asking the Supreme Court to take the case raised several issues, and the Supreme Court specifically said, we're only going to address the issue about Chevron deference. So that shows that they're not ducking this question. They're taking it head on.
Does this approach the level of overturning major aspects of the New Deal?
I think it would come a bit close to that. In my view, the doctrine that's even more core to the New Deal is the so-called non-delegation doctrine, which perhaps you've talked about on other shows, which is an even bigger problem of the legislative branch being able to punt to the executive branch through overly vague laws. So this wouldn't be quite as important as non-delegation, but I would say Chevron is second only to that in terms of reigning in the administrative state.
It's very exciting. I mean, it's got me kind of sweating and hot, but that might also be the caffeine from my delicious Founding Flavors coffee, which we sell exclusively at apforlibertyshop.com. Thomas, is there anything else? I'm a good capitalist, as you can see. Thomas, is there anything else surrounding this case, or maybe just anything in general that you'd like to plug or share with our listeners today?
Oh, well, if people are interested in the most recent Supreme Court term, they should tune in to our webcast on September 18th, day after Constitution Day. We're having a conference, and we'll be releasing the Cato Supreme Court Review, which, as you said, I'm editor-in-chief of. And you can both read and watch panels about all the big decisions from this past term, about affirmative action, Indian Child Welfare Act, all of the big ones that were in the news. You'll see a lot of the top law professors from across the country lending their insight and putting them in perspective.
It is Tommy Berry, research fellow at the Cato Institute for Constitutional Studies, editor in chief of the Cato Supreme Court Review, and his very first time on the show. This is very exciting stuff, Tommy. Thanks very much for getting up so early and joining us to help educate our audience on this very important Supreme Court case. We appreciate you.
Absolutely. Thanks for having me.